Welcome to our second annual CPD series, examining the contemporary relevance of the transformational legal reforms established by the Whitlam Government. Today, our speakers will investigate legislation to establish a new system of federal administrative review that would abolish the AAT and establish a new fit-for-purpose federal administrative review body to be named the Administrative Review Tribunal.
Well, ladies and gentlemen, we're very fortunate to have a remarkable lineup of distinguished speakers today. We'll hear shortly from both the President and Deputy President of the Administrative Appeals Tribunal, and can I say to your honours that we are sincerely grateful that you've joined us today and privileged that you'll be addressing us.
In a democratic society, the system of review of administrative decisions must operate to ensure governments and public servants are accountable to the community, especially when unfairness or illegality is present.
But I'll focus on four features of the ART which provide a greater measure of structural and operational flexibility than the AAT currently does. If I were to summarise the overall effect of the changes, I would say that they will enable the ART to operate on a truly national uniform basis and to be more agile than the AAT is.
It is always difficult to assess where one is going without understanding where one has come from. As we stand here at the dawn of the era of the Commonwealth Administrative Review Tribunal, the cart, it is an opportune time to examine the horse that came before the cart.
But it's up to government. The tribunal is part of the executive, it's part of government. It's up to government to make sure that the objectives are achievable. That when we say to the Australian people, you will have the ability to review government decision making and you will have that ability to do it quickly, that's up to government to make sure that the resources are there for the tribunal.
The starting point, I think, for analysing responses to robo-debt is to understand just how serious the conduct was which resulted in it being introduced, which was a deliberate misleading of Cabinet.
My topic today concerns the role of advocacy in administrative decision-making as against decisions reached on the papers. Insofar as concerns the role of advocacy, an immediate potential tension is apparent between, for example, the emphasis on expedition in subparagraph B and the focus on fairness and responsiveness to the diverse needs of parties in subparagraphs B and C.
Sometimes it takes the unearthing of a structural defect causing reprehensible harm, such as robo-debt, for reforms to be made. We hope the ART legislation is passed as soon as possible and the tribunal can get on to doing their very important work soon. Thank you.